And then the other things are exceptions that appear in the record. So every time you do a search of the public record, you'll see deed restrictions, you'll see easements, plat maybe is recorded, and the restrictions really should be looked at, because you could have a restriction that either limits what can be constructed, may affect density, square footage. Could be a lot of issues that if you're buying raw land and want to subdivide it into townhomes or single-family residences, it could impair your use of that property. So if there are restrictions, I usually get a copy of those, read them, to see if there's anything in there that's going to be a problem for me. I mean, I recently did a hotel closing in New Tampa, and there were a couple issues there. One of them was a maintenance agreement among the two commercial parcels, obligating them to pay $5,000 a month for capital improvements and repairs of the parking and access. My client didn't know that. He really didn't factor it into anything when he bought the hotel. But we got that out of the commitment. We let him know about it. He reviewed it, and he accepted it. But that same client also found that the hotel was actually built within the wetland setback. So you got a $4 million building in the wetland setback. Bit of an issue. And it took a few weeks to resolve, kind of. We weren't insuring it, we were representing the buyer. But we contacted the title company, the underwriter. You have the agent, who's like me, on the guy in the street who sells title insurance. And you have the underwriter who insures it. Some people think I insure it. I really don't. I just get a commission for selling title insurance. But we looked at it, and we found out that the water district had approved the encroachment of the building in the wetlands. And we found out the city of Tampa had also approved it. So we felt pretty good about ourselves. However, I did have to drive to the water district and get a copy of their file, and the city of Tampa destroyed their file, but they were kind enough to do a nice letter. So we kind of resolved that with one exception. The hotel was actually on platted land in a planned unit development, which meant there was some commercial and some residential all combined in one. The only thing we were afraid to approach was the association to see if they would waive the encroachment. Because even though the water district and the city had agreed to do that, the homeowner association would have a right to enforce the setbacks. Our client is now wondering whether we want to disturb them or just buy it because the title company has agreed to insure over it. They will remove the encroachment as an exception on the title policy. They will provide our client with what's referred to as a comprehensive Form 9 endorsement that insures them for any loss that they may sustain by the forced removal of that building. I'll go over those endorsements with you in a bit. But it's so important to read through these, especially not only to see if there's any problems presently with improvements on it, but if you're buying raw land, you need to see what issues there could be. And some of these things you can go through. In this case, this is platted land, so you really don't have too many things. You do have some restrictive covenants. And I always read those to make sure they don't prevent any commercial use of the property. This property happens to be a commercial property. So you need to read the restrictions and make sure it doesn't limit your use. In that hotel one we represent the buyer in, there's actually a restriction that says the hotel can't exceed 80 rooms. And then you start wondering, boy, it seemed kind of big. It actually had 80. So, but there are things you need to look at, because even if you can close it, buy it, and get a loan on it, you have to keep in mind that one day you're going to sell it. And you don't want a diligent buyer to look at the title and say, oh my God, I don't want that. So even though you might be agreeable to taking it subject to something that you perceive as a minor problem, you never know. You may end up with a peculiar buyer that says, if it's not perfect, I don't want it, especially if you're going to spend $4 million. So you need to go through all of these exceptions. Many of the exceptions can be removed, and this is where your surveyor comes into play. Many of these things, these exceptions, show easements. You'll see, sometimes you see 5 or 6 easements shown on the title, even on platted land. I'll see all these easements, and you say, well, it's not going through the lot because it doesn't show. When you plat land, you take your raw land, either meets and bounds or your government surveyed land, and you submit it to the county for them to approve it. Everyone that has an ownership interest or a lien interest, like a mortgage, has to sign the plat and consent to it. So you're usually pretty good with platted property, and when you see these easements, they're usually easements that are to the neighborhood, providing some service to the community. They're not necessarily going through your lot. But if you have raw land, you need to make sure that you don't have something recorded that's going to impair the platting of the property. For example, I had a client buy some land in Pasco County, Zephyr Hills, and he thought he would buy it at a good price from a bank and subdivide it. And he put his $50,000 deposit down. I said, when you get your title commitment, let me look at it, make sure there's no problems. And I looked at it, and I see at the very bottom there's a reservation of mineral rights. Immediately, whenever you see mineral rights, you get a little nervous. They were privately owned. They were retained some 50 years ago, whatever, and periodically they were mentioned again. But those mineral rights, and unfortunately through the variety of reasons, but primarily because someone would die and leave it to their 8 kids, whose kids would die and leave it to 8 more kids, you ended up with 64 people having an interest in these mineral rights. So I told my client, I said, you need to get them to join in the plat. He goes, I can't do that. I said, no, I know you can't. So we objected. So the seller's attorney said to me, well, the mineral rights are more than 30 years old, the right of entry is barred. Which means, even though there's mineral rights, no one can enter upon the land and mine them or explore them, which is fine if you own the surface rights. Under normal circumstances with mineral rights, if you own those mineral rights, you have a right to enter upon someone's land and drill, which obviously is an impediment to selling a house. So in this case, I told the attorney, I said, in normal circumstances, that may be correct, because there's a statute in Florida that says after 30 years, if they're privately owned, right of entry could be barred if it's not referenced within any deeds within a 30-year period. Unfortunately, Pasco County, which is one of the few counties, has a mineral rights tax bill. You go figure. So they have a separate assessment and tax bill for the mineral rights. So you cannot extinguish them in Pasco County. So I told my client, I said, I wouldn't buy the land because you're not going to be able to. I said, I could get maybe my underwriter to insure it, but when you're selling houses and you disclose that, I said, it's going to kill some deals for you. It's not a. So he walked from it. I also had a transaction in Naples, Collier County, where a developer was buying a huge amount of land. Same problem, mineral rights, owned by the Collier family. And the Collier family, when they bought all of Collier County, whenever they sold land, they reserved the mineral rights. I guess at that time they thought maybe there was something worthwhile there. Well, it turned out to be extremely worthwhile, because when I objected, the seller's attorney kind of said, I don't know what to do. So I called the Collier family, and I talked to their attorney, in-house attorney, and he said, let me get to you our in-house title examiner to confirm the mineral rights. So they had guys working for the family doing, their only purpose was to release mineral rights. I said, well, before you do that, what's it going to cost to get a release? And he says, it's 5%. I said, of what? Of the purchase price. I said, really? So those mineral rights can be a problem. If it's state-held mineral rights, it's not a big problem, because once you plat land, they're gone. The right of entry is gone. So oftentimes you'll see some mineral rights, and at the very end, it'll say, without right of entry, which is okay. But if it doesn't have it, and whenever I see mineral rights, I asked the title company, I said, I want that modified to show no right of entry. I don't expect you all to understand this or remember it. Maybe you'll understand, but not remember it. But the key is, when you get a commitment, you may want to have someone review it for you within the time frame to make sure that there's nothing there like a mineral rights reservation that's going to prevent you from platting the land. I mean, that could be a devastating thing for you. If it's state-owned, it's much easier. If it's less than 10 acres, there's no right of entry. Once it's platted, there's no right of entry. So you can work with those. But when they're privately held, it's a real problem. And that's an exception that I'm always aware of. And actually, many title companies will show as a standard exception here mineral rights. They don't even give you an OR book and page. They just say mineral rights held by the owner or any prior owner in title. And I'll object and I'll say, if there are in fact mineral rights, I need to know the recording information. I need to review them to determine whether there's right of entry or not. And when they immediately tell me, well, we really don't have an answer, well, then you need to get rid of that. Now, there's also a comprehensive Form 9. It ensures against the forced removal of encroachments. It also protects you against mineral rights. Now, the only other thing on these exceptions, actually there's a variety of them, is if you have waterfront property, that can be an issue as well. You may have filled lands like Cobarth Isles or Davis Island, which could be a problem because when you fill land which were formerly submerged, the state or government or the United States government may have an interest or ownership interest in that land. So when it's filled, you're actually filling land that the government owned. So if you go through the proper permitting process and all that, that's fine. Anything done, I think, before 1955 is fine. But occasionally you get some land that was filled or added to. I had a piece of land where they, maybe a 100-foot lot, and then all of a sudden the survey shows it's 150 feet, and you go, what happened? He said, oh, I just filled it. So that could be another issue. A lot of these things can be taken care of if you address them, because there are endorsements or provisions in the statutes that could provide some coverage. So you need to go through these. It's very important that your surveyor get them, because when he looks at these, he may say, this easement does not affect the property. And once you get the survey and provide it to the title agent, they'll remove it. And I always like to know where everything is on a piece of property. So if you're buying a 50-acre parcel, and it refers to all these easements and restrictions and agreements and resolutions with the city, to provide utilities, you look at all this, you go, it's probably not a problem. But then you start reading them, and you go, it's a bit of a problem. So what you do, the surveyor gets a copy of your commitment and all of the B2 exceptions, everything here, and he'll look at it and plat it. So when you get your survey back, there'll be surveyor's notes or title commitment notes, and he'll say, Schedule B2, Item 4 does not affect the subject property. Or number 5 affects the subject property and is depicted on the survey. So you can look and you can say to the title agent, the things that are not subject, remove. And then you need to make a business decision that those things that are actually shown on the survey are not going to impair your use of the property. That may require you to sit down with your engineer, your surveyor, or someone to determine how that could impact the subdivision you're planning. Now, once you get the commitment and have the survey done, you normally contact the title agent, and I do that for you in instances where you give me something to do. I mean, you know what I mean. If I get the contract, I'll do that, and I'll ask them to mark up the commitment, and usually they will. Sometimes they fight you over things, but otherwise they're pretty good. Now, so that's a sample commitment. I brought with me somewhere a Form 9 endorsement. Every lender, when they do a closing, require certain endorsements which provide, in many instances, affirmative coverage or additional coverage to the lender. And I think I have, maybe I don't. Maybe I got it separately. Is it a Form 9 there? Yeah. Oh, very good. This provides coverage. So if you do have an encroachment, this says if an improvement encroaches into whatever it may be an easement, it could be a wetlands, we will pay any damages sustained by the forced removal of that improvement from whatever it's encroaching upon, which can be in connection with a expensive home or a building, could be huge. But this says we'll pay for it. Now, they don't do that unless they're confident no one's going to force the issue. And in many instances, in order to get this, they may require the consent of either the association or the surrounding homeowners. I had a builder buy a lot in South Tampa, and he was going to build a house that encroached upon a setback. And he said, I got the city to agree. I said, yeah, but the plat still has a 25-foot setback. He said, well, I don't think anyone will bother me. I said, well, you're building a house. That's up to you to do. So he said, well, I don't want to have a risk. I said, well, then we need to try to do something. So I talked to my underwriter, and they said, we will issue a Form 9 endorsement protecting him for any encroachments, but we want him to get the consent and approval of his plans and a survey showing how it would encroach from the surrounding neighbors. So immediately he said, just the guy next door? I said, no, it can't be just the guy next door. I said, a couple homes on each side, the people across from you, the people behind you, any one of them could object. Let's eliminate the ones who are more likely to object. So he actually did it with some resentment. But that was another instance where he's planning to build a house. You're looking at the plat or the survey, whatever it may be, and you see, look, the house, that's why I gather you get a foundation survey done. Make sure you put it in the correct location. But it's so important to get this to your surveyor. It's so important to have someone review it. I don't expect you to review it and perhaps see any issues, but it's very good to get an attorney involved to look at it and give you his input as to what may be a problem for you in the future.